I may be present, madam. Criminal appeal 1299/23. Your lordship is to direct the matter be listed today because the
For what?
doctor's marriage of the petitioner interim bail by file करଥିଲି
Special notice. केबे marriage?
आदि पे हेतला
29th ना marriage? 29th marriage था।
List करन केमती? और special notice राखो।
Okay.
आपण instruction आनी केमती?
जाइथला I have taken instruction.
देखो तो number दियो से file मगे दियो।
1200
Initial order है पर constitution।
Pardon me, we have filed an application for amendment of prearment.
Amendment of?
Prearment. Prayer.
हाँ जी तो।
Supplemental list, item number 1.
Wait, delay to be confirmed. Admit call for this one. Engagement declared out. जो मुझे age so ना लिखते हैं जो मन नहीं कर सकते. Next also same है ना? ये सब 302 केस तो
Minor.
देखी दी चंदी.
Minor.
बेटा तब देखी दो 302 लाइसेंस के जन्म की नहीं ना?
Item 3.
302 delay condom. For the trial court record and sworn prison case. This yearly next admit call for the trial court record sworn prison case. And 4 also same. Yes.
Item 5.
Item 5, your lordships, on behalf of my senior Mr. P.K. Padi, your lordships, I pray for an adjournment, 1 week adjournment. Item 5. Item 5, I'm forgetting. This is my today and the factor.
The land counsel for the opposite party bank files the counter affidavit in court today. I will serve a copy on the copy of the counter affidavit has been served on the land counsel for the petitioner to sit some time to go through the same. Put up this matter on such and such date, give another date. Yes, next.
In both the petition you are filing? Counter?
No,
Separate counter?
Both are interconnected matter.
No, are you filing one counter or separate counter?
Separate counter.
Separate count.
Okay.
Okay,
Mr. Counsel, you have filed counter only in which number?
Second case.
Then what about the first one?
And both are interconnected.
अरे सेठी यही हमको पचारू आपन को आपन जेंती कहिले आज 6799 रे मध्य काउंटर देले और सेपरेट काउंटर 7479 देले. So you have filed only counter affidavit in 7479. यही लोग land counsel how would it 6799 देले. The land counsel for the opposite party bank submits that since WPC number 7479 of 2025 is interconnected to this writ petition and counter affidavit has already been filed in this said writ petition. The bank does not want to file any counter affidavit in this writ petition. This matter on such. Yes, next.
Item 6.
My lord, here in this case, the opposite party number 1, my lord, that is the name and address is also wrong. So I file an amendment petition for correctness of this name.
Where is that?
That is my lord. I'll file today.
Oh, you will file. So give a copy.
My lord, it is
You-
not signed, so petitioner is.
No, have you filed before the registry?
No, I will file
Actually,
today.
the land counsel for the petitioner submits that he intends to file an interim application for amendment of the contract. What amendment करिवे?
Opposite party number 1, name and address.
अच्छा, for amending the name of the opposite party. केवल सेती ପାଇଁ करिवे?
Number 1
Opposite party number 1
and his address.
and his address. सेती तो if this matter on such and such date with the interim application, if any, filed by the land counsel for the petitioner. Copy of the interim application be served on the land counsel for the Union of India. Yes.
Item 7.
Next,
Item 8.
Ashok.
May I please, Your Lordship? Your Lordship, here I am challenging the order dated 29/4/2025, passed in OA number 175 by
Have you
2025.
supplied the copy of the writ petition?
Yes, Your Lordship.
Please, the counsel for the Union of India, Mr. Pari. What is your prayer here?
Your Lordship, prayer is to quash the order passed by Central Administrative Tribunal, page 248, Annex 11.
Come to that.
Yes, Your Lordship. Your Lordship, the OA was rejected in premature ground, where the order was passed under Section 20 of CAT Act 1985. It was mentioned that the application was premature because the representation was given on month of April. That was the result declared on 28th March 2025. But the petitioner has already filed the representation on 30th November 2024. As per the provision, as per the rule given by SEC, advertisement, Your Lordship. Exam was held on 8th October and.
No.
Yes, Your Lordship.
Your representation is dated on 1/4/2025.
That is after the declaration of result, Your Lordship.
So,
But Your Lordship, the question in the question number 5, where the petitioner was claimed to give the marks, that has multiple answer, Your Lordship.
the tribunal says that you have submitted the representation on 1/4/2025 and without awaiting for the order on that representation, you have rushed to the tribunal.
You have
and
filed the OA on 15/4/2025.
Yes, Your Lordship.
So,
First, only after 14 days.
then
Yes,
how,
Lordship.
what is the purpose of filing representation then? So everybody is waiting. The moment you will file the representation, they will pass an order.
No, Your Lordship.
Then?
Your Lordship, on November 30th, 2024.
No, that is not the case. It is mentioned that the representation was filed on 1/4/2025 because the result was declared thereafter you file the representation.
Yes, Your
If
Lordship.
any representation is filed earlier, that is goes. Now you filed a fresh cause of action as arose and you filed the representation on 1/4/2025. So you must give them the authorities some breathing time to consider your representation.
Lordship, appointment was already started and.
That would be subject matter of challenge. If somebody else is appointed, his appointment will be quashed. But when you are filing the representation and without giving the time immediately, so that is how the observation has been made.
Lordship, petitioner scored 123 marks that which he didn't get.
So representation is required to be given.
Yes, Your Lordship.
Then if it is under the provision, it is required to be given. Then under section 20, it says that the remedy has to be exhausted thereafter only the tribunal will entertain.
Yes, Lordship.
You have resort to a remedy which has not been exhausted as yet because the representation has not been decided. So wait for the representation to be decided.
Your Lordship, I can understand, but in November 30, that is also there.
Have you moved an application for dispensing section 20? You could have moved an application saying that, see, in view of urgency, section 20, like order 39, you have to give notice. You can move an application.
Yes, Your Lordship, but the question which was marked wrong in the petitioner's answers.
Merit, don't go to merit.
Yes, Lordship.
Have you requested the court that please dispense with requirement of section 20 in view of urgency and decide my OA? Have you said that?
Yes, Your Lordship, but they said.
Where is that? Show that application.
So that
Show that application.
Your Lordship, they have said that we have to wait for 6 months to consider the representation, Lordship. If you have.
Where they said 6 months?
nothing has been stated.
They have.
If it is anything orally stated, we do not know.
What you should have done is, along with OA, you should have moved an application saying that dispense the requirement of 20 because of the urgency. And the court would have passed some order. You straight away went within 14 days. So the court is rightly passed this order.
Because 22A says, come to 22A. if a final order has been made by the government or authority or officer or other person competent to pass such order under the rules, rejecting any appeal preferred or representation made by such person in connection with the grievance. So the person shall be deemed to have been availed the remedy. So after the representation is disposed of or rejected, you will
Cause
have
of action
the-
arises.
So
Then you get the cause of action to approach court. Or otherwise, you should have moved an application for dispensing 20.
Your Lordship, mail has also been done. They have not given any response, Your Lordship. And though that was
That-
very,
the period is also been prescribed in 22B that if they do not dispose of the representation within 6 months from the date on which that representation was made, then also you can approach. And if you say that the matter is of urgency, as has been pointed out to you, should have prayed for dispensing with that because
Saying that I can't wait for 6 months because of the urgency involved in this matter. So dispense 20 and decide my matter. You should have moved a separate application. We can give that liberty later. We will give that liberty. You move separate application.
the writ petition has been filed by the petitioner, Sandeep Kumar Baral, challenging the impugned order dated 29/4/2025 passed by the London Central Administrative Tribunal, Cuttack, Bench, Cuttack, in way number 175 of 2025. It appears from the impugned order that the petitioner submitted a representation on 1/4/2025 highlighting
Representation in accordance with
in accordance with 22A of the Central Administrative Tribunal Act on 1/4/2025, ventilating his grievances. And
15/4.
he filed the original application before the Central Administrative Tribunal on 15/4/2025. The London Tribunal, having taken note of the provision under Section 20 of the Central Administrative Tribunal Act, has been held that since no final order has been passed and the applicant has filed the representation on 1/4/2025, the OA is premature and accordingly dismiss the OA. Section 20 of the CAT reads as follows: court to answer. The London Counsel for the petitioner submits that in view of the urgency of the matter, the London London Central Administrative Tribunal should have entertained the original application and should not have held that it was a premature one. Since no application has been filed for dispensing with the requirement of Section 20, showing the urgency, we are of the view that there is no infirmity or illegality in the order. However, if the petitioner files any such application afresh or to highlighting the urgency in the matter, the same shall be considered in accordance with law. Accordingly, the writ petition is disposed of. Yes,
Appearance may be noted.
yes, Mr. Pari is present.
Mr. Samanta.
You must have given the names of that.
Yes, this item I just.
देना थी
देना
अच्छा दे yes का ना कोई तो
WhatsApp करो इसके सामने.
yes next
Item 9.
हाँ argument item 7 तक
Item 7.
Here in this case, this petitioner was a branch manager of the concerned bank, where Section 13 notice has been issued to him. But subsequently, here I am also the loanee in the same bank. I have availed a loan of ₹4 lakhs from the same bank. Subsequently, my lord, disciplinary proceeding was initiated against me, and my lord, I was suspended. That is why I could not, because of my financial stringency, I could not pay the bank's bills.
And subsequently, after suspension, I was also removed from the service, terminated. And after some days, my lord, after 20 years gap, my lord, this matter was subject matter challenge before this honorable court, that termination order. And therein, my lord, this termination order was revoked and the punishment was reduced to compulsory retirement. My lord, in view of this compulsory retirement, I will get the area dues, GPF, PPF, etc. I am ready to pay, my lord. The amount which is right now pending for the concerned bank, there, my lord, I am ready to pay the amount. I have made an application for the concerned bank that the money which is to be realized in my favor out of this service benefit, that may be adjusted to my loan account. And what is the differential amount is there? I am ready to pay. If at all any differential amount.
What are you challenging?
What are you, this is,
They are notice only.
approach, the, appropriate forum.
Well, I have approached by making an
I think before
application.
notice has been issued, then this, you did not, then sale notice has been, everything is complete, so.
Well,
we have-
As per Annex 9, my lord, they have demanded 18 lakh rupees something. Otherwise, my property will be subject matter.
Once 13-4 issued means you have to approach the appropriate forum, or we will not entertain. Rest thing, you say that is, maybe that is interconnected, but we are now concerned with the annexure 10 which you are challenging.
Well,
And it clearly indicates that possession notice has been issued.
yes.
That is, so once that is issued, then what remains? You have to
My
approve
lord,
it.
I am ready to pay. Whatever amount is there, my lord, I am ready to pay.
Yes.
The amount which is right now pending for the concerned authority,
No, no,
that will
you-
be adjusted in my
So
account.
many decisions, the writ petitioner, one has filed this writ petition challenging the sale notice of the immovable properties under Annexure 10. It appears that the possession notice was issued on 22/11/2024 to the petitioner regarding taking possession of the secured asset standing in the name of the petitioner. And the possession notice was also published in daily newspaper. Even though that notice was issued on 22/11/2024, but till the issuance of notice for sale on 6/6/2025, the petitioner did not pay any amount to discharge his liability in full to the bank. That is, therefore, the bank has proposed to sell the secured assets on 11th July 2025. In view of this settled position of law, a decision product court for the 13-4 notice for alternative remediable. Yes, with petition is disposed of. Petition is at liberty. Yes.
My lord, 15 days time will be given so that I will.
We are giving liberty, whatever.
Till then, my lord, I will be protected.
ଆପଣଙ୍କର ବର୍ତ୍ତମାନ ସମୟ ଅଛି 11 ଜୁଲାଇ ପର୍ଯ୍ୟନ୍ତ ତା ଭିତରେ ଯାଇକି ନା approach କରନ୍ତୁ. Yes. Next.
My lord, another thing is, my lord, the prayer I have made here that this area amount may be released in my favor.
No,
The
we-
decision of this honorable
We are
court
saying
may not
that
be
we
passed.
don't have jurisdiction
No,
alternate
I do
remedy.
understand.
How can we pass the
No,
order?
no, my lord, I do understand.
Yes.
But I will file separate writ application. I may not be debarred. The decision of this honorable court, I may be debarred to file another application. That may be.
Why have you made joint prayer?
Well, that is fine.
Huh? ଏଇଟା ତ annexure 10 ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି
ଆଜ୍ଞା।
ତାପରେ ପୁଣି ତା ଦେହରେ କାହିଁକି ଗୋଳା ଗୋଳି କରୁଥିଲେ ସେ ମୋର ସର୍ଭିସ ବେନିଫିଟ ତା ଦେହରେ ଆଡଜଷ୍ଟ ହବ ଅମକ ହବ ସମକ ହବ
ସବୁଗୁଡା ଗୋଟେ ପିଟିସନ ରେ ହେଇଯିବ।
ଭାବିଲି ଗୋଟେ ଥରେ ହେଇଯିବ ବୋଲି।
it is ହଁ ହେଇଯିବ ତ ସବୁ it is made clear that though apart from challenging the sale notice under annexure 10 other prayers have been made. We think that the petitioner is at liberty to file separate petition for challenging for seeking those remedies.
No,
Yes.
oh, that's.
Item 9.
Item 9 and for the petitioner.
Yes.
The petitioner was serving as a constable in the CIS, sir. And he was seeking to challenge his termination order. I brought it to CAT.
To withdraw this time and file a
Yes, sir.
better application because she wrongly filed application with the CAT.
The CAT
CAT
is
reject.
on the count.
Taken the
jurisdiction.
CAT is, she
Yes, sir.
came here and it definitely count it is single judgment.
CAT prima facie doesn't have jurisdiction. I approached the CAT.
Either they go to
And I
single
challenge-
You should have
judgment,
gone to
withdraw and file it.
file the writ petition before single judge.
File a
Withdraw with your liberty.
much.
File a memo to that effect.
I'll just file.
Just give him.
Write down that liberty also.
Yeah.
The learned counsel
Much
for
of-
this petitioner, Subhalatmi Devi files a memo to withdraw the writ petition seeking liberty to file a fresh writ petition. Fresh writ petition. The memo is taken on record. The writ petition is disposed of giving liberty to the petitioner. Yes,
Yes, much.
now, Mishra, Deputy Solicitor General, Karna Lekhivaga.
Mr. Harichandran, along with me, D. Harichandran.
My lord, item number 7, excuse me. Item number 7.
Sorry, Rani?
Presence.
ଆପଣଙ୍କର ନାଁ ଲେଖା ହବ ଅଛି ମିଷ୍ଟର ଟୁନା ସାହୁଙ୍କ ନାଁ ଲେଖିଦେବେ ଲର୍ନ କାଉନସିଲ ଫର ଦି ହାର୍ଡ ଲେଖିଲା
Yes.
ଆଉ କଣ ଲେଖିବା କି ପେମେଣ୍ଟଲି ଅପୋଜ ନା ହଁ ମୁଁ କହିଲି ମିଳିଲାଣି ମେଣ୍ଟେନେବିଲିଟି ଅଫ ଦି
Item 10,
I challenge this order against the order of the County Central Tribunal Procedural Court. It is 16/2024 university. Minister Lordship filed. I say for 2 weeks time, it was filed the counter. I have not enforced the counter.
अच्छा ओरिजिनल एप्लीकेशन ଟା ଖାଲି ଦେଇଛନ୍ତି ଆଉ କାଉଣ୍ଟର ରିଜେଣ୍ଡର ହେରିକା ଫାଇଲ ଦେଇଛନ୍ତି ନା ନାହିଁ
All pleadings.
all pleadings go listen the land counsel for the petitioner submits that in this writ petition the petitioner Pramila Varik has challenged the order dated so passed by the Land and Central Administrative Tribunal in so and for better adjudication of the case he wants to file the counter affidavit and other pleadings taken by the respective parties in as much as he has only filed the original application filed before the Central Administrative Tribunal and for such purpose, some time may be granted. It is this matter, 2 weeks after. 14 तारीख, 14th, yes.
item 11,
Matter matter, Lord. It should go to the fine bench. Not related to the surface actually.
Key matter पूछेंगे?
MSM.
The Land and Counsel for the Mr. Dale and Counsel appearing for the petitioner submits that the matter relates to MSME matter. Matter relates to MSME and it is it has to go to the assigned bench. The registry shall do the needful placing the matter before the appropriate benches. Next.
item 12,
I don't know my lord, I have the petitioner my lord. Procedural in this case, my lord, they have gone.
Speak little louder.
I am for petitioner, my lord. I am the Foxy Council in this case, my lord, and we have on A, my lord.
Which one?
Next week, another date, my lord.
Which one? Item number 12.
12.
After lunch only, I think you will gather energy. If you had breakfast, then you must have some energy to speak louder. Speak
This is a
louder.
bail application. What do you want?
I prefer adjournment.
Adjourn.
No, you see, this is jail criminal appeal of the year 2015 and this interim application for bail has been made in the year 2023. So in jail criminal appeal, you should not, because they are 4 persons and you are engaged by the secretary of this Orissa High Court Legal Services Authority. Don't take so much of time. You see how many times you have taken adjournment.
At least you got the Foxy Council, my lord. I prefer last chance, my lord.
You produce the custody certificate and criminal antecedent, right? And his conduct inside the jail.
Jail conduct.
Jail conduct. गोटा गोटा से जेल में भी बहुत ଗଣ୍ଡଗୋଳ କରନ୍ତି କେସ୍ ଫେସ୍ ପାଇଁ ତ ସବୁ ନିଆନ୍ତୁ ବାହାରେ ନଥିବ the land counsel for the petitioner IA number so and so this is an application for bail. What is your good name? Also appearing on behalf of Mrs. Aditi Hota seeks for an adjournment. Land counsel for the state seeks some time to produce the custody certificate number 1. Instruction relating to the criminal antecedents, if any, against the petitioner. So also the conduct of the petitioner inside the jail. List this matter in the week commencing from 14th July 2025. Yes.
Item 13.
Yes.
Directed custody certificate and registration.
Yes.
I'm receiving the custody certificate,
Yes.
but criminal action for criminal antecedents that part is not.
How many years is in custody?
8 years. 7 वर्ष 7 मास 11
Whether the bail application has been earlier rejected?
No man.
Not rejected. So it's a case under 302.
Well, Sunil is put for
So
there is
eyewitnesses are there.
I will say there is contradicted to each
No,
scenario.
no, just tell us. We are asking you. How many eyewitnesses are
Two
there?
items.
Who are there?
5 and below 10.
PW5 and PW10 are the eyewitnesses, and who is the PM doctor?
PW8.
What is the weapon of control?
Weapon is the axe, double axe.
PW5 Rokande. So also I know this one beginning hours at about from myself and deceased husband sitting in front of the one. By that time, accused and their own persons entered inside my house and came out. All in a sudden, accused dealt 3 blows by means of tabla on the head of my husband, for which my assistant severe bleeding injury died at the spot.
PW10 is the minor, the granddaughter of that deceased.
Deceased. Also stated that the Marla Tadere
Is the son of one of the
accused is my elder father, deceased was my grandfather. आंख भीतर कौन रिलेशन कौन थी डिसीज
What is the daughter? You.
नहीं 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 ଆପଣଙ୍କର appellant ଆଉ deceased ଭିତରେ relation କଣ?
ବଡ ଭାଇ ତାର ବଡ ଭାଇ ସାନ
ଦି ଭାଇ
ଜମି ଭାଗ ଦେଇଥିଲା ସେ ତାର ଭାଗ କରୁଥିଲା ଆଜ୍ଞା PW one of the accused ଭୁବନ ବେନିଆ ଭାଗ କରୁଥିଲା ଆର କିଛି ରିଲେସନ ନାହିଁ 4 ଜଣ 5 ଜଣ ଯାକ ଆସିଲେ ଆସଲ୍ଟ କଲେ ଇଏ ବୋଲ ଇଏ କହୁଛି ଇଏ ମାରିଛି ବୋଲି କିନ୍ତୁ ଅପୋଜିଟ ପାର୍ଟି PW10 କହୁଛି ଇଏ ଖାଲି ବେନିଆ
ସମସ୍ତେ କହୁଛନ୍ତି ତ ବିଚିତ୍ର ମାରଲା 3ଟା ବ୍ଲୋ ଦେଇଛି ଆଉ ତାବଲାରେ ଆଉ
କ୍ରସ ରେ କହୁଛି ସିଏ along with 5 others ଆସିଥିଲେ ବୋଲି ମାରିବା
ନାଇଁ ଆସିଥିଲେ ଯେ ମନେ ମାରଲେ କି କୋଉଠି
ବ୍ଲୋ କିଏ କହୁଥିଲା
କ୍ରସ ରେ କହୁଛି
ଓ କିଏ କହୁଛି
PW5 କହୁଛି
PW5 let us see
Cross Malot, Bhubanamania is my nephew.
କୋଉଠି ପଢୁଛନ୍ତି
which paragraph
And paragraph from cross is on paragraph 2.
ହୁଁ
Bhubanamania is my nephew, being son of the brother of my husband. Now he is cultivating my share, land and bag of basis. He is my bhagtan. There is no road in front of our house. He said, was dark, nobody was going to passing through at the time of occurrence. There is no street light in front of our house. The accused and other person named above are holding thenga body. Other person, accused and other person. Holding thenga and body. The accused and said person assaulted me.
not to the deceased assaulted me means that PW5
Extaplically. Police and thenga and an accused and said person also assaulted me.
And where from you got that
Police
the
has
other persons who had accompanied this appellant also assaulted the deceased? That was exactly your submission. So where is that you have elicited in the cross-examination? Neither from PW5 nor from PW10.
That's a place of occurrence for us.
ये अभी कौन आमे बेल ले देखियो ब्लो काउंट दी छंदी आपण PW8 रे
Medical report could be 2 laceration is there. If a 3 blow is there, and medical report says 3 laceration is there, 2 laceration.
ପଢିଥିବ ସେଇଠି ଗୋଟେ ପଢାଯାଏ
Final hearing,
ଫାଇନାଲ
overall you have to see.
সেটা হচ্ছে deep cut linear injury exposing the skull bone. You see the appearance ରେ ଲେଖା ହେଇଛି deep cut linear injury exposing the skull bone with linear fracture of the skull bone. ହେଲା ତା ଛଡା ହଉଛି ସେଇ temporal region ରେ laceration ଦିଟା ରହୁଛି ତେଣୁ ପୁରା କାଟିକିନି ତାକୁ skull bone ଟାକୁ ଇଏ କରିଛି. Cause of death was due to hypovolemic shock due to injury to the body. You will get that the criminal antecedent 8 ବର୍ଷ ରହିଛି
7 ବର୍ଷ 7 ମାସ 11 ବର୍ଷ।
What,
ସେ ଇଏଟା
what is
ରିପୋର୍ଟ
your age? What is your age?
Age 51.
50.
Land Counsel for the state has produced the custody certificate, which is taken on record. However, it seeks some further time to produce the instruction relating to the criminal antecedent, if any, against the petitioner. It is this matter will be commencing from 14th of July 2025. Yes.
Item 14.
Adjournment. This year 24. କେବେକାର କେସ୍ ଏଟା?
Last date of hearing also you sought adjournment.
Occurrences of 2020.
ତା ଆଗରୁ ବି adjournment.
Eyewitness ଅଛନ୍ତି?
ଅଛି।
Hmm?
1 and 4 eyewitnesses.
କୋଉଥିରେ ମାରିଛି? What is the weapon of offense?
Stab.
Stab wound, knife, belly. Capital Hospital, then SCV Medical Hospital, postmortem conducted, doctor found so and so injuries, and dura was torn and opined that the injury, so and so in corresponding injury on the left lung was antemortem and caused by sharp penetrating weapon and homicidal in nature. That death of the deceased was due to pneumonia as a complication of so and so injury.
Internal injury.
Inside wound. Oh, aswad mention is made by so and so on behalf of Ms. Pratyusha Naidu for adjournment. List this matter on such and such day. Land Counsel for the state shall produce the custody certificate as well as obtain instruction regarding the criminal antecedent, if any, against the appellant. In the meantime, say 14/7/2025. Next.
Item 15.
Convict is a lifer. Already completed 16 years in custody.
Have you got that certificate, custody certificate?
Maybe not see, but please grant an entry. For 3 months.
No, that is ଆଗରୁ ଲେଖା ହେଇଛି order ରେ ଯେ ଆପଣ ଏଇ ଯୋଉ period କହୁଛନ୍ତି for 15 years, more than 15. ଲେଖା ହେଇଛି order dated 18/12/2024 ରେ ଲେଖା ହେଇଛି ଯୋଉଥିରେ ଆମେ bail ଦେଇଥିଲୁ 3 ମାସ ପାଇଁ. So what is his conduct?
Conduct was very, and I wait for a period of 3 months.
Conduct କଣ ଥିଲା କି ଗଡବଡ କରିଛି କି ତା ଦେହରେ? ମଗାଇନି ମୋର ଲେଖା ହେଇଛି order ରେ ମଗାଇନି କଣ?
That's the idea. We, on the test basis, we generally give 3 months is to see the conduct.
Let's undo. The IN number so and so, there is an application for bail. It appears that the petitioner after availing the interim bail period of 3 months as per the order dated 18/12/2024, passed in IN number 1222 of 2021, has surrendered and is now judicial custody. Mr. Mahapatra and Counsel appearing for the appellant submits that the petitioner has remained in judicial custody for more than 15 years. Stop. The learned counsel for the state seeks some time to obtain instruction regarding the conduct of the petitioner while on interim bail. Put up this matter in the week commencing from 14th July 2025. Yes.
Item 16.
Mr. Dhar, DP Dhar. Password wrong.
Item 17.
Before having custody saying, my lord, within 2013. More than 12 years, my lord.
अच्छी की चीज custody certificate.
No, my lord, custody certificate.
आगुर जाइए बेल जाइए interim bail.
My lord, we gone on interim bail.
को order है.
My lord,
हाँ अच्छी लिखा है 11 years more than. ठीक है जी. So
At the very least, because of just now received the file, that is the case of the murder one of judicial officer.
Judicial officer.
Judicial officer.
Judicial officer.
Baleshwar judicial officer.
अच्छा.
Judicial officer.
No, it was rejected, of course, on 39/2024. The paperwork has been prepared.
No,
Stop. IN number so and so is an application for bail. Grand Counsel for the state has pointed out that on 39/2024 in IN number 1738 of 2022, the bail application of the petitioner, petitioner or petitioner?
petitioner.
The bail application of the petitioner has been rejected. Land Counsel for the petition submits that the petition is in judicial custody for more than 11 years. In view of the rejection of the bail application, 39/2024, at the office and the period of detention in judicial custody, let the office prepare the paperwork of the case for early hearing. The judicial officer will moderate further submit that it's a case of murder of the judicial officer. Release this matter on the second week of August 2025 for hearing. Yes, next.
I need to pardon me. Name of Ms. Das and SVP may be deleted from the bottom.
Is Das
Yes, Devi.
is Devi not be reflected in the questions book. Second week of August 2025. Yes, next.
Item number 18.
Once you mistake, I may be allowed this.
Your power is there.
No, but on the Mr. Piquedas.
No, you see the prisoner's petition has been filed
On the in the name of Piquedas.
PK Das,
Pranab
Kumar Das, and Wakalatnama has been filed. We have to pass an order first on that prisoner's petition. So that has not been passed. So let me give you the prisoner's petition dated 14/5/2025, in which a prayer has been made for engagement of Mr. Pranab Kumar Das as his advocate. Mr. Das has already filed wakalatnama. So the wakalatnama is accepted. The names of the earlier engaged counsel, except Mr. Pranab Kumar Das and associate, shall not be reflected in the cause list henceforth. So what do you say now?
मला ते IA still pending for bail.
Uh,
तर मला ते IA number 2089/2019 मला.
yeah.
That the appellant is considered.
I'll be requiring the deposition copies. I'll collect. Since it is a jail criminal appeal, I'll collect the deposition copies.
This interim application has been filed by some other counsel because
Yes,
at that time you are not in.
This one.
So you file a fresh interim application, taking instruction from the client, right? The learned counsel for the petty appellant submits that since he has recently entered appearance, he wants to file a fresh interim application highlighting the present status of the appellant, and therefore he does not want to press the IN number 2089 of 2019. Accordingly, IN number so and so is disposed of as not pressed. Yes.
I may be pardoned, that I may be allowed to receive the PCI copy of the chairman. That is that.
Trial court record.
2 months.
Asha, the deposition copies of the witnesses is supplied to the learned counsel for the state as well as to the learned counsel for the appellant in their respective pen drives. Yes, next.
Item number 19.
But I pray, manner, there is one IA. But I say it can be listed for final hearing, manner. And let the IA lie over. So I'm pressing for final hearing if the lordship.
You file an interim application for early hearing,
Yes, ma'am.
indicating about the period of detention, etc., etc.
Well,
So that will be considered and appropriate.
for that, will also be listed for next week.
We are just listing it next week
Yes.
and you do the needful. We're not
Right.
mentioning anything. Mr. Das appearing for the appellant or appellant? Appellant. Seeks for an adjournment till next week. List this matter next week. Yes, next.
Item number 21.
These are actually.
Yeah.
Filed an IA, that is 1018 of 2025 on behalf of appellant number 1. Because of.
Who had gone on bail?
That's appellant number.
Twice on an interim basis.
Here.
Appellant number
Twice on
1.
interim bail, appellant number 1, regular bail, appellant number
1
2.
and 2 and 3.
No, just a minute. Appellant, there are two appellants.
There are three
Three
appellants also.
Three appellants.
Yes, madam.
Appellant, this application has been filed by appellant number 1. Okay. Appellant number 1 interim bill kithor jayche? Dui thora.
One survived order dated 23/7/2024.
23/7/24.
Another is on 20th of December
1912 or 20?
20th of December 24. है ना?
I am appeal for the informant mail. I copy not all mail.
I copy देना दिया चाहो ठीक है जी कहूँ. Madam, what is the conduct of this appellant number 1
Yes.
during the interim bail period on 2 occasions?
Yes, sir.
Have you received the instruction?
No.
Like, received that instruction?
The IA has been filed on medical ground.
This IA?
Yes,
Yes,
on behalf of the appellant, he is
They say
suffering.
they are terminally ill in terms of the NALSA guideline. I have to take instruction whether the KCO dilated cardiomyopathy comes under the terminally ill or
66 years.
That is the instruction that he is now at present admitted at Niagara Hospital.
That is either 70 years or terminal illness.
terminally ill.
ये की कौन सूत्र कौन?
He is 67 years, so he doesn't come under the
terminal illness.
terminally ill. He is as per them, they are suffering from KCO dilated cardiomyopathy and they have undergone a surgery in the SC. I have to take instruction whether that disease comes under the definition of
That
terminally
you
ill or
have to
not.
take instruction.
I'll take instruction.
At present, he is in Niagara Hospital. From the jail, he has been referred to the hospital. Therefore, I have.
Let him obtain instruction about that. Let him because you have referred to that special campaign.
Yes,
for release. So special campaign, the first part applicable
My
होगा
lord, sorry.
70 years. The second part से कौन एटा terminal illness रे आसीबो कि नाही तेणु सेटा से देखिबे द्वितीय कथा होची आपनकर कंडक्ट ए दुटा देखिबे लेखन and you serve a copy on the
I'll serve a copy. Yes, ma'am.
Mr. S. Panda, Land Counsel appearing for appellant number 1 submits that the appellant number, this is an application for bail for appellant number 1, the QIA number. No? Appearing for appellant number 1 submits that the appellant number 1 has been granted interim bail twice on, that is on 23/7/2024 and on 20/12/2024.
1912.
Jildi baar पहले
That is 1912.
just let us see that. Hey, check करो.
Order number
19
19.
बार 19 बार ठीक है. 19 बार. The and after availing the interim bail period, you surrender. Appellant number 1 surrender at right time. Stop. On perusal of the grounds taken in the interim application, it appears that the petitioner has taken a ground. Has it taken a ground that in view of the special campaign conducted by the NALSA for release of the terminal ill prisoners, the petitioner may be released on bail in support of the illness of the petitioner. Some medical documents have been filed. The London Council for the state seeks some time to obtain instruction on these documents and also whether the disease for which the petitioner is suffering from comes within terminal illness or not. She also will she submit that she will also obtain instruction regarding the conduct of the petitioner while on interim bail on the aforesaid two occasions. So, put up this matter on such and such date, let a copy of the interim application be served on the land and council for the informant in the meantime.
May I pray one thing? He is now been referred to the Nagar hospital. May I pray my
Mr. Panda submits that the petitioner, medical documents say to the petitioner is now admitted in Nagar hospital. With the instructions.
And a report be called for from the jail and may I pray next week any day if your lordship will.
We commencing from 7th, like 7/7/20. Yes.
Item number 22.
ଆପଣ କେବେ ବେଲ୍ ରେ ଯାଇଥିଲେ କୋଉ ଅର୍ଡର ରେ?
7/10/2024
କେତେ ମାସ ପାଇଁ ଯାଇଥିଲେ?
3 months.
ଠିକ ସମୟରେ ସରେଣ୍ଡର କଲେ?
21/2025 ରେ surrender କଲେ।
ଗଣ୍ଡଗୋଳ କିଛି କରିଛନ୍ତି?
No, my lord.
ରିପୋର୍ଟ ଆସିଛି?
That report has not been
Instruction, giving Govardhan ଆଉ health condition.
କଣ ହେଲା?
Health condition ପାଇଁ instruction ଯାଇଥିଲା last. No,
That order was also passed here on the last date that he has to obtain instruction regarding the conduct of the petitioner while on interim bail.
That report has not been.
And apart from that, you made a submission that Dhruvo Guru was suffering from paralysis. So on that submission, they want to obtain instruction. What is your instruction? এই অর্ডারটা পাস হয়েছি 25/4/2025 রে আজি হচ্ছে তারিখ হচ্ছে কেতে তারিখ 26/6/2000 কেতে মাস ହେଇଗଲା 2 মাস ହେଇଗଲା ଆପଣ ইনস্ট্রাকশন ନେଇ ନାହାନ୍ତି ଟିକେ ରହିବେ ଧୈର୍ଯ୍ୟ ଧରିବେ ନା ନାଇଁ ପଚାରୁଛୁ ପରା
Sending the letter to the IIC Sambalpur Sadar, but in fact in the Sasam
ଆପଣ ଚିଠି ଲେଖି ଦେଇ ଚୁପଚାପ ବସିଗଲେ ସେଇଟା ତ କୋର୍ଟ ଅର୍ଡରଟା କମ୍ପ୍ଲାଏ ହେଇଗଲାନି ନା କୋର୍ଟ ଯୋଉ ଚାହୁଁଛନ୍ତି ଯାହା ସେଇଟା ଦବାକୁ ପଡିବ ଆପଣଙ୍କୁ ମୁଁ ଚିଠି ଲେଖିଦେଲି
next week
the land and council for the state 6 time till next week to obtain instruction as per the order dated 25/4/2025 place this matter on on 4th of July 2025. 4th টা next week নয় কি?
Item number 23.
ସମସ୍ତଙ୍କ ପାଇଁ one has died. Appellant number 2, appellant number is the husband of the
No, appellant.
appellant number my everything
আসছে
ଆସିଥିଲା ସେଇ ବେସିସରେ ହଁ ସେଇ ବେସିସରେ ତ interim bill ଦେଇଥିଲେ wife filed an application for appellant number 3 only with the wife of the appellant number 2 during incarceration matter the appellant number 2 died while undergoing treatment at SC Medical College. Your lordship call for a report.
ସେଟା ହେଇନି।
bill ଦେଇ ଦେଇଥିଲେ submission ହେଇଯାଇଥିଲା ତାପରେ ମୁଁ
yes
ତାପରେ ମୁଁ ଗୋଟେ certificate death certificate ଫାଇଲ କରିଛି surrender certificate death
The land council for the state has not
my lord.
You also submission like land council to the restricted parts of the land. This certificate filed the this criminal appeal so far are the number 2 of the land.
Devendra Patti.
How come kind of the
IA file করছো appellant number 3 the wife of the appellant number 2 তারই ପାଇଁ IA file করছি
Yes.
ଅଫିସରେ evidence
12/8/24 ରିଜେକ୍ଟ ହେଇଛି।
This implication is on the basis of the confession of the appellant number 1. ସେ 13/3/2020
স্বাধীনতা দিবস পরে
Deposition copy may be served on the information.
Yes.
Item number 25.
Mayor. Custody for about 11 years, 6 months. So the case is concerned, it is alleged on the 11th day, 21/2018, when a meeting was organized by the village agriculture people.
Yes, my lord.
Village agriculture staff.
Paper book already prepared. Paper book is.
Village agriculture on 21/2018, when a village meeting was convened for the purpose of some agricultural purpose, and some agricultural officers were there. At the relevant time, it is alleged that petitioner along with 2 others they reached there, and there they challenged the activities of the village agricultural officers as to why they have not paid the money of the concerned accused, and a hitch arose between those persons. At the relevant time, the deceased who was sitting there, he intervened and he challenged. Therefore, it is alleged that the present petitioner, by means of a knife, gave 3 blows, one on the belly, one on the chest, and another on the also chest, madam. And the other person, and he ran away. And thereafter, the case has been now PW.
Yes, my lord. PW 3, 6, 9, 10 are right.
PW 1 and PW 10. PW 1 is informant and PW 11 is the brother of the informant. Is there supported by some persons have supported?
Leading to discovery is there. Yes.
That is there. But one thing I can point out subject of appreciation. The hitch, because of this hitch and because of the sudden call, things are up. But if I take note of that, I have a case.
My lord, the petitioner has no enmity with the deceased, my lord.
Yes.
Peaceful intervener.
He challenged. That is the
no.
challenge. That is evidence. He was there.
The deceased was also sitting in that particular meeting, madam.
While the appellant was assaulting the VLW, the petitioner intervened.
This is,
As to why you are the deceased intervened and asked why you are.
15-20 minute ଗୋଟେ quarrel ହେଲା, that is the evidence of the witnesses. 15 to 20 minutes that quarrel occurred, and during that particular process, it is alleged that things has occurred. Using circumstantial 7.5 years. I don't consider some intent.
Item number 26.
The petition is in custody minute. The convicted of 302 along with other offenses. No, first one. During trial, we have
Eyewitness should be.
eyewitness came out. Yes, sir.
So better the circumstance decision.
The whole time the judgment was faced is 35 years.
Some of the
There are 5 circumstances are given. Is 35 years. Internal case 16. Maybe
the relationship between Immigration and
yes, sir. In case in hand, there are destitution in order to assume the criminal liability against the accused persons as relied upon following circumstances. As circumstances is that prior to the marriage of the accused Situpanda to the deceased, there is a relationship, a love relationship between the accused Situ and Vishwanan Gupta, the petitioner.
Decision on that one will be.
Pratipushna Purohit. Pratipushna Purohit. Vishwanan Gupta. People को appellant से तार बेल है ये जोने आदर appellant
अरे regional trial this to
regional trial face कर लो से बेल आउट नहीं तो ये पर्स
that number with this year
841. I am appearing in the 841.
We take SC.
with it
41.
41 of 2024.
yes so we take it Situ Panda.
So, any difference between this Situpanda and Vishwaranjan Gupta?
No, Situpanda, I would like to suppose the PW 18.
Situpanda is standing on different footing. He is not the assailant. Situpanda is the wife of the deceased. There was an extramarital relationship between the wife Situpanda and the appellant.
Yes.
Yes.
This land. He conspired and.
Yes.
That's it. Yes. The first circumstance is that prior to the marriage of the accused Situpanda with the deceased, there was a love relationship between accused Situ and Vishwanan as they are childhood friends and belong to same village. Secondly, the second circumstance is the call details report showing conversation of the accused Vishwaranjan with the deceased over phone prior to death of the deceased on 19-10-13 and also conversation of the accused Situpanda with the accused Vishwaranjan on the same date. Third, thereof as the last scene on 19-10-13 evening, accused Vishwaranjan and the deceased were seen together at Bhedavahar inside a Tata AC 4-wheeler, and thereafter the deceased was found missing. The fourth circumstances is missing of the deceased on 19-10-13 evening after his last seen in the company of the accused Vishwaranjan at Bhedavahar. Fifth circumstances is that prior to the death of the deceased, the extramated affairs of Situpanda with the accused Vishwaranjan was within the knowledge of the deceased, for which there was frequent quarrel between the deceased and his wife Situ, which was noticed by the deceased brother and other family members, and concerning with this matter, once accused Situpanda had threatened to the deceased either to kill him or to commit suicide. In the last week, page 36.
the six the disclosure statement of the accused Krishna Gupta, 27 of the Evidence Act, and the recovery of the dead body at his instance from Hanuman's jungle, Hindi.
So more circumstances are there against you than the lady. So last scene is on 19th of October 2013
Yes.
inside a vehicle, and at your instance the dead body was recovered from the jungle.
Prior to the recovery, the other persons were at the spot, my lord. You can count the evidence of PW 3 and 23, my lord. They have stated that prior to the dead body is recovered, other persons were at the spot, my lord. It was accessible to all. They are the police constables, my lord. PW 3 and 23.
After how many days the dead body was found?
On 19/10/23, my lord, the deceased was missing. And 20/10/13 missing FR was lost, my lord. And 2/11/13, the dead body was recovered.
Missing report kebe diya hala?
On the next, my lord, 20/10/13, my lord.
Who has lost that?
The brother of the deceased.
Dead body टाକୁ ଗାତ କରିକି ବାହାର କରିଥିଲେ ଯୋଉ ସେ ପୋତିଥିଲେ।
Two circumstances are more than the circumstances cited against Sidhu Panda. One is 27, second is last scene.
Last scene, the witness, they have not.
PW 18 the last
Last time he has seen the accused identifying the port, my lord, not doing post investigation.
No, this, what about your knowledge when it is buried somewhere? It was within your exclusive knowledge, and it was disinterred at your instance. That is the evidence. ଆପଣ କହିଲେ point out କଲେ ଏଇ ଜାଗାରେ ମୁଁ ପୋତିଛି ଖୋଳିକିନି ବାହାରିଲା, ତ ଏଇଟା ଅନ୍ୟମାନେ କହୁଛନ୍ତି ସେଠି ବୁଲୁଥିବେ।
They were at the spot, my lord.
ସ୍ପଟ ରେ ଯେ ତାଙ୍କର ସେମାନେ କ'ଣ ଡେଡ୍ ବଡି ଦେଖିଥିଲେ? If it would have been lying in open space, matter is different, but that is buried somewhere, as he stated, and you pointed out that place, and from that place it was found out, and it found it to be homicidal death. So it was exclusively within your knowledge, apart from the previous motive behind the commission of the crime, extramarital relationship with the deceased wife, and then last scene. This is another very clinching circumstance, that at your instance the dead body was recovered from a place where it was buried, and it was within your. A question must have been put to you in the 313 statement. So what is your reply? How do you came to know about this? How it came to your knowledge that at this place the dead body was buried and it was a homicidal death? Who are the witnesses who, apart from IO, have stated about that disinterring the dead body at the instance of this appellant?
The
last scene ପଚାରୁନୁ ମ
Leading to disclosure.
ଏ ଯୋଉ ଗାତ ଖୋଳିକି ବାହାର କଲା, ଆପଣ କହିଲେ ପରା ଗାତ ଦେଖେଇଲେ, ଗାତ ଖୋଳିକି ଗୋଟେ ଜାଗାରୁ ବାହାରିଲା ଜଙ୍ଗଲ ଭିତରେ।
13 and 22 ମିଳିଲା।
କିଏ କିଏ?
13 and 22. And 22.
13 and 22 ର question କୋଉଠି ପଚରା ହେଇଛି accused statement? Now, question number 28 ଟାକୁ ଦେଖନ୍ତୁ. It transpires from the evidence police recorded your statement, the disclosure statement. You led the police team and the witnesses to Dhanu Banu's jungle. In presence of executive magistrate, you showed the place where you had buried the dead body of the deceased. And thereafter, at your instance, the dead body of the deceased was exhumed. And he noticed stab wounds on the chest of the deceased, so and so on. ଆପଣଙ୍କର ଉତ୍ତର ହେଉଛି कौन झूठ बात, मैंने पुलिस को कहीं पे नहीं लिया, मैंने किसी को गाड़ा नहीं. So you have taken a plea of denial.
Referring to the evidence of PW3 and 23.
Hmm?
Evidence of PW3 and 23. Question of that paragraph 3. We cannot say as to who on 2/11/23 was the diary in charge of the PS. We will not know. As to
PW3 कौन?
police witness number.
No, let us say at least the IO must have stated about that recovery. And that statement which you have given under section 27, that must have been marked also as an exhibit. Mark any exhibit. So much of statement which led to the discovery of the fact is admissible under section 27, and that is exactly, you cannot take that it was lying in the open space, it was accessible to all, therefore it is not an incriminating material against me. So
prior to this arrival of this petition at the spot, many persons are at the spot. Because
many person at the spot, खुला जंगल में पड़ता था, many person at the, you can say that समझते तो देखते ले, and a fact already known and it cannot be rediscovered. That's a different matter. But it is in case of not that nature.
In the presence of the accused magistrate, matter the statement of the IO, page 3. Hon'Ble jungle and inside the Bhanubhushan
jungle भितरे गात पोता है कि नहीं?
He identified the place where the
homicidal death
has been buried. By that time, the accused magistrate had
Custody since
spot.
केबे रही
and during trial he was on bail. After 4 days custody, he was released on bail by the Supreme Court.
the total custody period.
The date of judgment in custody.
Anand custody certificate on. The learned counsel for the state petition has submitted that the appellant was granted bail in the trial court after remaining in judicial custody for 4 years.
More than 4 years. Sir.
More than 4 years. Let the learned counsel for the state obtain instruction regarding produce the custody certificate, so also obtain instruction regarding the conduct any criminal antecedent, if any, against the person. Yes.
Number 27.
May please.
Yes.
Now 9 accused persons were tried.
Instruction.
And out of them are
1 minute. Last time we asked for instruction.
yes,
Criminal antecedents and all.
The C and custody certificate. That fact has not been.
Your manner.
Last week, lots of directed the criminal antecedent and custody certificate.
File.
They are not restricted.
Get it next week, we'll take over.
But in fact, the judgment shows that the custody, period of custody.
No, apart from that criminal antecedent, it didn't so quite long. Budhavar rab do no.
Your Honor, you also kindly appreciate so far the criminal appeal number 31 is concerned. Out of 9 matters, I have segregated them. One, Gautam Krishna has filed criminal appeal number 31.
आसी जाओ मिस्टर धर से पिसमिल कहीं ये करे सबूत को तो एकाठी सुनानी हो लिस्ट इजी बुधवार दिन आसी हो कौन लेकिन तो the learned counsel for the state submits that the matter may be taken up next week to obtain instruction as per the order dated 6/5/2025. এটা লিখিবে IN number 49 of 2025 যেটা ফার্স্ট ক্রিমিনাল appeal আছে না list this matter on 2nd of July 2025 with CRLA number 50 of 25 and CRLA number 430 of 25. Yes.
Item number 28.
The appellant is convicted under section 304 and 34 of IPC for life and with a fine of 10,000 in
There
default.
is delay of 66 days.
Yes, madam.
Life imprisonment.
He was in custody since the date of arrest, madam.
We are asking you, is it a case of life imprisonment?
Flag A is the interim application, taking condemnation of.
IN number so and so, this is an application for delay. The stamp reporter has pointed out that there is delay of 66 days in filing this criminal appeal, considering the submission made by the land council to the respective party. And since the petitioner has been sentenced to RI for life, we are inclined to condone the delay in filing the appeal. Accordingly, delay is condoned. IA is disposed of, hard admit, call for the trial court record, interim applications for bail and stay realization of fine to be considered.
I will find
Ailini,
Each one.
nahi, that copy diyandu, file is madam.
Yes.
They don't copy diyandu. Shall be considered after receipt of the trial court record. In the meantime, the Land Council for the appellant shall supply the deposition copies to the Land Council for the state. Yes.
Item number 29.
Please, madam. My lord, here, a 60 years old man is also convicted under section 302 and also sentenced to undergo the imprisonment for life along with the fine of
Second of-
10,000.
685 may be 66 days.
Yes.
प्रथम देखना
Delay.
फर्स्ट है भी 66 days.
Yes.
अच्छा ठीक है. All right. Life imprisonment.
Life imprisonment.
Same order. Delay condone. Admit. Call for the trial court of either be bail out stay file AG. Deposition copy to be supplied to the Land State Council. Yes, next.
Delay of court.
Item 30.
Delay হচ্ছে 405 দিন. এটা লাইফ ইমপ্রিজনমেন্ট. আচ্ছা সেম অর্ডার করবেন. Delay condone. Admit, call for the trial court record. There will be a application for bail and stay realization of fine to be considered after receipt of the trial court record and deposition copy to be supplied. Yes, next.
Item 31.
May I please, Your Lordship, life imprisonment. There is a delay. The appellant has been convicted under section 3.
2 days delay. 2 days delay. Delay condone. बाकी सब सामान admit करेगी.
Oblige.
As there out किसी को the application नहीं just देख लो. No, there is no other application. The जो bail out state and the selecting. Passport.
Also item number 16.
Have you verified
Yes.
the marriage thing?
Yes.
Verified?
Yes.
Marriage.
Diyon the report से diyon.
Madam.
Lekhondo. IA number 1661 of 2025. This is an application for interim bail on the ground of the marriage of the only daughter of the petitioner, which is stated to be held on 29/6/2025. We asked the Land Council for the state, as per the order dated 24/6/2025, to obtain instruction on this interim application. Today, the Land Council for the state has produced the report received from so and so, which indicates that the marriage of the daughter of the petitioner is to be held on 29/6/2025. The report is taken on record considering the submission made by the land council for the respective parties. Grounds taken in the interim application report produced by the land council for the state. We are inclined to release the petitioner on interim basis. 4 weeks. Matter will be listed on such and such date. The land council will appellant shall file the surrender certificate. Yes. I will get it. That's all.
You mentioned this.
The recollect had appeared virtually the last weekend, the date was.
We got it fixed
Yes,
today.
yes.
Yes, oh.
So this matter was directed.
No problem. I can understand this.
The date.
Yeah.
So let's take a look at the order alert. Here also indicated that the interim order till 26.
No, that has to be obviously extended.
So obviously till next date means obviously.
Not listed means obviously whenever it is taken up. It's automatically listed.
This matter was, we
Yes.
passed this marriage, that was also posted to today.
Okay.
But he mentioned at the first hour and we listed by way of a, so sometimes it
In fact,
happens.
I'm extremely sorry. I wanted to come at 10:30 because of the police van near the State Bank. My vehicle was struck there. So I had to wait for 10 minutes. Then I had to.
This matter was mentioned at the first hour, so we listed it by way of.
I understand, Lord. That's my.
Otherwise you could have listed.
Sorry, my fault. In fact, I wanted to.
See, there is something, but Asila, maybe somewhere it is there and it could not be listed. So.
No, anything.
Because 24th, it is not incoming because I have another matter. Something.
So there is some problem that as per the direction of the Honorable Supreme Court, a special bench has been constituted which has to take only the criminal appeals on Tuesday and Thursday. So that is the problem.
And the bench will be also broken.
There's a
Special bench.
A different bench and.
Can I request, tentatively list it on 24th because I have to be here on 24th for another.
Let it be 25th also.
No, you take
23rd.
not on Tuesday and
23rd.
Tuesday or Thursday.
That's what I have it on 25th. Fine. Have it on
25th or 23rd?
25th would be better.
25th.
25th.
But the interim order to continue, we also indicate that.
That is problem.
So just
There is
just a
no
minute,
interim.
just a minute, sir. So that interim order, I think Mr. Natarajan also agreed. Till the next week, till today it is there, I think we understand. So there, the other day when the interim order was passed, in fact, I should not say I have been informed, that a lot of police force were there to demolish all those buildings.
No.
There is no
Because the interim order.
You had one minute, you will have to
State
it's at
party.
2000. No, the state has consciously not been made a party. I am appealing for MCM, both of us, Mr. Natarajan. 2015, this writ appeal was filed challenging a judgment of the Honorable Single Judge, dismissing the writ petition. Almost all incentives under the package are under package that has been extended. They have been provided with employment, land, alternate land. Many of them have constructed, only a few of them asking for more. The people, those who are minor at the time of acquisition in 2007, they say that in the meantime they have made major, so you give them employment. 84 people, they are asking for further employment, notwithstanding the fact they have already been provided with the employment by the MCA. It's not in a
This matter was supposed to be listed today. Inadvertently, it could not be listed. But we are asking you if the shortest possible date can be given by you on consensus. We can fix it, but
next week any date.
But he say that
24 mile be here. You have 24.
No issue.
Alright,
25th you said now. Okay, 25th.
No, if your lordship can take it up at 2 p.m. so that it would be over. It's a writ appeal against a judgment without.
we will list it and please come, we'll take out at 10:30. Positive.
Right.
You mentioned it should be listed the matter, है ना? There is something कि बेले बेले गोटे गोटे रही जाऊँ. So
That's the interim order, sir.
it will continue till next date. That is already an order.
Right.
If it has not been listed, means it is obviously it will continue till 25th, right? There is no problem.
If petition has been dismissed, my lord, I fail to understand what can be the.
Okay, but since we are directing it to be listed on 25th, if we will not pass an order today, then
You see, the status quo order is till next day. Date was fixed today.
Yes.
So it needs to be extended. So there will be a confusion.
do one thing. Let
It be only one petitioner is there. Let it be confined to the one person.
No, they are, we will, the status was there.
It can't be a
Actually, the
general order.
application was filed.
No, it can't be a
Sir, it
general
was
order.
general, sir, it was a
One
general
petitioner,
application.
Will not add anything.
No, sir.
It can't be.
We have also filed all the cases. Yes.
it is in dwelling house in question that has been mentioned.
No, there is no dwelling house. There was a court commissioner who has not given a report just.
It is as you say, Advocate General, that it's a general order. It's not a general order. If we have mentioned that the daily dwelling house in question, so in we have a dwelling house and.
You can't be dwelling order. There is
So
only
in fact, I have
one
already
petitioner
filed the
who
whole
can apply. So many, that it's only one petitioner. How can it be applicable?
No, that IA 2939 is also there.
One eye.
File is not.
No, so as soon as
We are doing one thing, subject to what you say. We are bringing it by way of special notice today, but it will just be there in the, and we'll saying that on the consensus of all the land and council, matter is to be listed on 25th of July 2025. And
The interim order passed.
interim order
Yes.
extended.
Interim order already passed, will not add anything.
IA 2939 file is here. All the notices have been filed.
The land and council submit.
General.
Since the land and council submit that the matter was directed to be listed on 26/6/2025 and it has not been listed, therefore this matter was brought by way of the special official. Swan, so Mr. Mr. Mishra, Mr. Natnad, Mr. and Advocate General present on consensus of all the parties, list this matter on 25/7/2025. This matter will be taken up at 10:30 a.m. and the interim order of status quo passed on such and such date in IN number such and such date is extended till next week. That will be there.
Mr. Pandey, please give in writing.
Yes. Our indicated order, sir, since special notice not going, but IA 2939.
I am a copy by look.
Total file ही नहीं हम पकड़े, ये just खाली order टाको देखिए ना.
उसको अच्छी तो. That's the understanding.